either one of you. Speak slowly and distinctly, so everybody in the courtroom, especially on the defense side, knows exactly what happened. Go.
So when my co-counsel ended up getting the case, he went to robbery homicide division back in August of 2020. He went back through all of the he went back through all the reports to make sure that he had everything, and he did. It turns out that in January 2024, there was a comparison done, and I want to be clear what we're talking about. There were two extended cases that were found at the crime scene by the victim in the case.
What was the date? What was the date that the expended casings were turned into the police?
The date of the incident.
It would have been 2 days later when he reported it to the police.
In other words, back at the time this happened in 2021.
All right, so the incident occurred on November 6th, so it would have been around November 8th?
Yes.
All right.
So that he turns them in. There's work done on the casing, unbeknownst to co-counsel, myself, obviously I was not on the case. They ended up doing a further examination of the casing. That examination revealed that in fact the two casings are consistent with having been fired. They're 9mm casings from certain 9mm handguns. There are some markings on the casings that are somewhat unique, and they can basically track them down to a much smaller subset of firearms that could have caused the marks on the casings. Included in that is Glock 43. So,
Hold on.
okay.
Did the report say that the casings could only have been fired from a Glock 43, or could a Glock 43 be among the type of firearms that the expended casings could have come from?
Let me read the exact conclusion. Items 1A and 1B.
Those are the casings.
Those are the casings. Each exhibits characteristics typical of aftermarket slides or a series of subcompact pistol frames, including but not limited to Polymer model PF9SS, Glock store model SS.
Wait, slow down because the court reporter needs to take
Sure. Polymer 80 model PF9SS, Glock store model SSA, and Glock model 43 and 43X. We have been given information that in fact, oftentimes, and frequently when you're looking at casings, you're not able to get a whole lot of information. But it turns out that the markings on these casings are a bit more unique, and they are not only consistent, but the examiner will testify that the markings he has seen very rarely, and that where he has seen them, where they've been recorded, are with a Glock 43 pistol.
What's the name of the examiner who did this ballistic comparison? Or ballistic
The examiner's
examination?
first name is going to be FIDAL, last name BIRA IMAH.
BIRA.
IMAH. So the way this came about was we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report that we're talking about.
Which detective?
In the attachment.
Detective Flores.
Flores?
Flores.
From Robbery Homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report. So he goes back in discovery, looks at emails. We don't have a report. So we instantly contact the defense, send them out the report. I want to be clear. The report is inculpatory, not exculpatory. So obviously, not only do we have no motivation to have not turned over this report, RHD has no motivation either. What's very clear is that they believe they had turned it over, and they did it.
What time did Mr. Flores bring this to either your attention or Mr. Frizoni's?
Yesterday afternoon, you want the exact time?
Approximately.
It was yesterday afternoon. We were in court. We went back to the office after court yesterday, and that's where we went back and looked to see, do we have this discovery?
So something after 4:30 p.m.?
The email is timestamped 3/18, but I got it when we, so it was essentially received but not gone through yet until I could get back over to my desk.
You conveyed this to the defense when?
We sent it to them at 5:21.
So about 40 minutes later, they're done?
Because the first thing we had to do was, we had to go back and see, or have we already turned this over? So, we not only emailed it, we called them. We explained the situation. The response at the time that we gave it to them initially was, well, this is the same thing that you have accused us with respect to the witness and the court's finding that they violated the court's discovery order. And we responded, no, this is completely different. You had interviews starting last August.
I don't want to get into who said what. I just want to know the sequence of events.
So at this point in time, we had a discussion. We sent an email at that point to counsel, and we included the court. There was an email sent late last night, at some point, by Mr. Tacopina. I did not see it until somewhere around 1, 2 in the morning. In that email, Mr. Tacopina cited the Hughes case. There were no facts in the Hughes case. I went in the middle of the night, I got the case, I read
I
it.
don't want to know about, this would be appropriate if you want to argue your position. I just wanted to know the sequence of events.
Right, I'm not gonna go any further other than to tell the court, I read the case, I then sent an email at roughly 3 or 4 in the morning. I sent it to counsel and I sent it to the court.
All right.
Can I have just one last factor on it,
Yes.
which is, I knew from past experience with firearm analysis that there would be a lab file or bench notes associated with the analysis. So I tried to immediately contact the lab to expedite and see if they could send that to me immediately, but they were not open at the time that I called. So we had to call this morning at around 6, and they scanned it and sent it over, and I sent that to the defense as soon as I got it.
How many pages is this report?
The
It's
report
ballistic.
is one
The
page.
report itself is
It's
one
six.
page.
One page. How many pages are there total of all the police reports, all of the discovery in this case? How many pages?
Regarding this one,
Regarding the total number of,
regarding this one.
No, I was,
no, the total number of pages involving this case and this investigation.
I would estimate 100 or over 100 pages. To be totally candid with the court, I haven't counted them, but that's just ballparking the various reports and things that we've received.
All right, I understand now the sequence of events, all right. Who wants to speak to the defense?
I think, I'll start, maybe Mr. Siegel, if I leave something out, because we tackle this together. We spent literally the night before, about 5 hours.
Okay.
trying to do it. So-
Speak slowly, the court reporter needs to get everything down, and I want everybody to know exactly what you have to say. Go ahead.
So, and I'll just stick with sort of the chronological order here. I'm not going to argue case law or anything like that, but aside from the fact that we lost 4 to 5 hours the night before our opening dealing with this, we this morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report. He testified at the preliminary hearing. After we get that report that says, in conclusion, that the subcompact pistol frames, including but not limited to, which means absolutely nothing. So it could be a universe that we don't even understand of other pistols, and then goes on to list 3 of them here. This morning, we got another 28 pages of backup data on this. Backup lab, I guess, report that normally comes with a conclusion report. We got this morning. And I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. We have an issue now with the jury. Obviously, it's a jury panel. It may affect, quite frankly, whether we would have kept or not kept a few jurors, one in particular. Now, we assured him yesterday he'd have a fair trial. You're going to have a fair trial. We've made issues regarding the veneer. You know that, Your Honor. I'm not going to rehash that. We're here. We're ready to open today. I don't even know how we're supposed to do this. This should be suppressed without question, because it changes the complexity of the case. We have to, at the very least, we have to quash this panel and start again, or strike jurors, reselect. I mean, I think even the district attorney said, okay, well, continuance is appropriate. We pick the jury. We're ready to go. This is something that, you know, to render fair and effective representation here, as we all assured Mr. Mayers we would have, in the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. 1 week. And that's their own lab, with their own on-staff experts. And it took them a week. How long is it going to take us? We have to go find somebody first, hope he's available, the trial will be over. We also have to make arrangements for the physical examination of the casings, scientific testing. I mean, if you look at their report, I mean, they cite like some of the basis for their findings is of the internet. They went on and cited all these websites and forums. I mean, there is so much work to be done here to even understand this conclusion. I mean,
All right, so what do you think?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our letters laid it out. I don't need to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to either break this whole panel. We need a continuance. We have to start again. What I'm asking for is you include this. This is after the jury was impaneled. This is a major piece of evidence that will require us to do a lot of expert work. That took them, their own department, a week to do. That's the only thing I'm requesting. Short of that, Your Honor, I can't even open if this is coming in, because I have to deal with the address. I don't even understand it. And it's we got on the way to court, we have 28 pages of backup data. So that's what I'm requesting. I'm requesting this to be included. It's after the jury's impaneled here. You know, as Seals pointed out, there's also a balancing argument under 352. You know, which I think is also something that's relevant here, including not limited to. But you know, we have this whole. I don't know what to say here, Your Honor. I really don't. I want to make sure he gets a fair trial. He's here, we're ready to go. We all assured him he'd get a fair trial, and this is, I've never seen anything like this. I'm not going to talk about the other witnesses, the late Brady disclosures, or the witness we got the name of for the first time last night. I'm not whining about that. I know that's what they want to keep doing. We both have had issues with that. That's fine. I will not make it an issue of it anymore. You've already ruled on that. Period, end of story. This is now a new one. You know, I don't want to get into, I told you so, but many people said to me this morning, I told you so, that this was going to happen. And I'm trying to keep my composure, Your Honor. I don't know if I've ever been this upset in a courtroom. in my whole career, both as a prosecutor and a defense attorney, I gotta be honest with you, this is not right, it's not fair to him.
You respond, Your Honor.
Hold on. Mr. Siegel, did you want to?
Yeah, the only thing I wanted to say.
I don't want you to repeat what Mr. Tacopina said. If you want to add something new,
No,
you're welcome to it.
I want to add something new, so I dovetail what he said with respect to the 352 arguments. And that is, the report says that the characteristics include, but are not limited to, certain firearms. That means the universe of firearms in this case, based on the face of that report, is extensively broad. So given that, Your Honor, I think even just the probative value of this is substantially outweighed by the danger of undue prejudice, separate and apart from the late disclosure. So it should be excluded on 352. But that's secondary to the fact that it's just incredibly late at this stage for all the reasons Mr. Tacopina said. So I'm just adding an additional factor.
All right, what I'm hearing from you then, it seems like you're talking out of both sides of your mouth with your defenses. Like it's irrelevant. However, it's so prejudicial that it shouldn't be allowed in. It's so inculpatory that it shouldn't be allowed in.
No, I don't think anyone said it's so inculpatory. We don't understand. Saying it's inculpatory is not accurate. No, I didn't say it's inculpatory, he didn't say it. What he said was there's a balancing test, because he says including but not limited to. All that simply means is, not that it's not inculpatory, not that, we just don't understand what this means. Not limited to means there's a universe of guns that have to be tested now. I don't know what not limited to means. So how many pistols does not limited to include? How many firearms is not limited to include? That's what it means.
Okay, who wants to speak to the people? Go ahead, Mr. Long.
I want to take things one step at a time. Counsel brought up and made a comparison to what has happened thus far.
Just a minute. Alex, could you please go out and tell the jurors that we're dealing with some logistical matters, and just please be patient, and we're going to have them come in as soon as possible.
Yes, sir.
Go ahead.
One, as the court is aware, there is no logical reason why either Robert Hamadai's division or the DA's office would have in any way not turned this over. It's very clear that this evidence only helps our case. Although again, as the court pointed out, on the one hand, Mr. Tacopina says, the client cannot get a fair trial. This is so apparently damaging. Yet on the other hand, he says, hey, it doesn't really matter because it includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Tacopina suggests that he can't believe that the DA's office did not know about this in advance, when I spoke to him on the phone last night, that is not what I heard. What I heard was, say, listen, this is a problem for us. We understand, I'm going to quote Mr. Siegel, there's no reason why you would have not turned this over if you hadn't, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already dealt with.
Okay.
I understand about the 2 defense witnesses.
Okay.
We've covered that.
Right.
Just deal with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder, and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. Investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecution because that was the theory of their case. Apparently, the head of the MATE team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over at the defense and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware, and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy. You didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor knew. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. We already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there's going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd. The idea that Hughes is in any way authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence in this case in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial, the defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to the defendant's manager, and that he is going to testify. So let's look at how this plays out. If the defense ends up being that, in fact, this 9mm magazine belongs to the manager, that in fact what was used at the scene was a starter pistol / prop gun, then although we don't believe that's credible evidence, that is where they're going. So here's what we're asking. One, there's no late discovery instruction because, as the court is aware, and maybe counsel is not, to have a late discovery instruction, the court has to find that we had the information and didn't turn it over. There's no reason why we wouldn't have turned it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, we contacted the court and we contacted counsel. Number two, the lab has told us that basically what they did in this case, to have someone else examine it is a very quick examination. And the amount of time that it should take for someone to examine it and end up being able to assess whether or not LAPD was accurate in what they found is ranging from a few hours to maybe a day. This is what we would propose. We would propose that at this point in time, we will not mention this in opening statement. We will see how the case develops. We will, if we believe that this is evidence that is going to be important, we will ask to admit that evidence later on in the trial. In the meantime, we will make arrangements for counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes was an extremely complicated accident reconstruction involving a vehicle where multiple individuals died. It was very time consuming. It's an extremely complex investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it.
I believe they've already.
We believe they already have the evidence. They have it with them. And we will get it to the defense. I just, this is related to the other issues, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously, on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yesterday, yeah,
I
pretty
did.
clearly.
I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So but I am correct. The court's original ruling was.
Yeah, that is what I said. Originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement. So I don't want you touching it.
Okay, understood.
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now that's not in a vacuum. It's very clear that the defense is not happy with this jury. They've made it clear.
Hold on.
No, don't interrupt.
Okay.
He didn't interrupt you, don't interrupt him.
It is
Go
very
ahead.
clear by the comments the defense has made in court, where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up, leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair, because in the end, Your Honor, they're arguing it both ways. As the court mentioned before I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not dreaming too.
All right, you don't have to go on.
Okay.
I believe I have enough information to make a decision.
All right, if you heard, please.
No, you can't.
I can't respond to what he just said about the jury.
it doesn't matter about what he said about the jury. That has stop. That has no bearing on any decision I'm going to make.
There's a record, though. There was a record.
I don't believe that you are unhappy with the jury. Mr. Lewin might say you're unhappy with the jury, but I don't believe you are. If you were, you wouldn't have accepted the jury. I believe that both sides are satisfied with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you are satisfied with the jury. All right, here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. If this late report involved, all of a sudden that it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter, that would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot A AP Relli, that would be very critical and crucial. If a firearm, if a 9mm was recovered, that could be ballistically compared to the casings, and that just became discoverable or became disclosed, I think that would be critical. But that is not what happened here. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday.